So welcome back, and I just will make a few remarks before introducing Judge Coburn. A little bit of housekeeping. One item you might note is that we've made it to the big time. This series is now profiled in the FDU Metro, so make sure you get a copy of this around campus and take a look at the story below the fold. Next week we'll make it above the fold, I'm sure. Next week we will have Ms. Lucy Dalglish from the Reporters Committee for Freedom of the Press. She will be discussing shield laws and the state of journalism in the 21st century, but her emphasis will be talking about the necessity or lack thereof for a national shield law and what protections it would afford to journalists, both traditional and of the Perez-Hilton variety. So make sure you come to that session as well, if you have the time. I'm going to begin today going back to the fall of 2005 when John Roberts, currently your Chief Justice of the Supreme Court, but then simply the most successful appellant lawyer in the world. John Roberts was then appearing before the Senate Judiciary Committee trying to make his case for why he should be appointed to the position of Chief Justice. And among other things, he emphasized his humility in the face of the law and in the face of the challenges he would embrace as a Chief Justice. I'll quote from him during these initial remarks so you can get a flavor of these comments. He said, "Judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. It is a limited role. Nobody ever went to a ball game to see the umpire." Later he went on to elaborate that, "I have no agenda, but I do have a commitment. If I am confirmed, I will confront every case with an open mind. I will decide every case based on the record according to the rule of law, and I will remember that it's my job to call balls and strikes and not to pitch or bat." Well, whatever the merits of this account of umpiring and judging, Justice Roberts was confirmed quite handily. I think something like a 72 to, you do the math for me. I'm obviously a political scientist, not a math major, but he had a decisive bipartisan margin in his favor and is, of course, our current Chief Justice. But that's only one picture of umpiring and possibly only one picture of judging. So perhaps unwittingly, well, certainly unwittingly, Judge Roberts gave us a nice connection to our current topic, our current discussion, which is an examination of the judicial role, perhaps, and the nature of judicial activism and how judges are selected more specifically. So what is the nature of umpiring? Well, Judge Roberts made one suggestion, but there's an old joke about umpiring, shared by umpires occasionally, but shared by judges as well, that gets to the heart of how umpiring itself is contestable. So in the joke, there's three umpires sitting around after a baseball game discussing what they do. Have you heard this joke before? No? Okay. So the first one says, "I'm a really good umpire. I call them like I see them." Okay? Balls and strikes, whatever your favorite sport might be or your favorite judging analogy might be. "I call them like I see them." The second one says, "Well, I'm even better than that," puffs up his chest and says, "I call them like they are." Okay? The third one says, looks at her compatriots smugly and says, "Until I call them, they aren't." So many thousands of pages have been spent in law reviews and academic journals trying to understand the nature of the judicial role, and to some degree, some aspects of that debate track this conversation. What is it that judges do? What is it that umpires do? How should we best understand the judicial role? Fortunately, to help us sort all this out in an hour or so, we have Judge Don Coburn with us today, who will be a most excellent guide in thinking about some of these issues. Judge Coburn has an interesting and varied background that plays in nicely to, again, the themes of today's conversation and to some of these issues underlying the umpire analogy. He also serves as a nice bridge between our recent conversations with the Morris County prosecutor and Professor Koppel and his discussion of forensic science administration and the human role in criminal justice. Don Coburn received his BA from Cornell and was a lieutenant in the United States Army. He subsequently obtained his JD, his law degree, from the University of Pennsylvania School of Law. He was a law clerk to Chief Justice Joseph Weintraub of the New Jersey Supreme Court, and also served as an assistant Essex County prosecutor. So again, to some degree, mirroring or reflecting some aspects of Mr. Bianchi's diverse background. He was in private legal practice and was then an elected representative to the 1976 Democratic Convention, served as a councilman for the Livingston Township, and in 1978, then New Jersey Governor Brendan Byrne appointed him Essex County prosecutor, where he served for 3 years and was then appointed to the position of Superior Court Judge, which all my students know is the name for the trial court in New Jersey. In 1996, he was appointed, I think they call it elevated, to the appellate division of the Superior Court and served in that role for until 2008, when he briefly retired, fairly briefly retired, and decided to, he can perhaps tell us why, decided to return back to the bench and in a temporary role as in accepting a recall to the appellate division. So given this background, Judge Coburn is, in my mind, ideally suited to help us start thinking about or to further refine our thinking about both judicial activism and judicial selection, two aspects of today's courts that are often touchstones for much criticism and complaining about the contemporary judiciary. So with that, please join me in welcoming Judge Don Coburn. That's your stuff. I will not take it. I'll leave you a pen.
Thank you, Professor. And good afternoon. As indicated, I'll be talking about, first about judicial selection, then about this concept of activism, which you'll find is perhaps more complex than you might have previously thought. And then I'm going to spend some time talking about Citizens United, which is the most recent opinion of the Supreme Court of the United States on the right of corporations to participate, thank you, in the electoral process by spending money from their treasuries. We'll talk about judicial selection first. I'm going to talk about it at the state level because at the federal level it is a settled proposition as to how it's done, but in the states there is a lot of variety. There is appointment, normally by a governor. There are partisan elections where people run in the general election at the same time as politicians are running, nonpartisan elections, and so-called merit plans. I'll want to suggest to you that after I've briefly discussed these various plans, I hope that you will come to the conclusion that the appointive system is the preferable system, particularly if it is coupled with something that is not common today, and that is with a form of merit selection to buttress the appointive system. Judicial selection, as you very well know, is very important. It was of concern to our founding fathers even before the Constitution of the United States was adopted. If you look in the Declaration of Independence, you'll find that there are about 27 reasons why we told England to leave us alone and why we were separating. The 9th reason had to do with judges. And what Thomas Jefferson wrote was that the king, quote, has made judges dependent on his will alone for the tenure of their office and the amount and payment of their salaries. In other words, at that time in this country, if a judge gave a decision that was displeasing to the king could cut off his salary or could fire him, remove him from office.